Okay, starting live in 3, 2, 1. Here we go. Welcome, everyone. Thank you for joining us for the 2021 UN South Asia Forum on Business and Human Rights. This is the session titled Improving Judicial Remedies. I'm Pravina from Q Designs, and I will be a technical facilitator for today. Both the chat function and Q&A will be on. So if you have any questions for the speakers, please use the Q&A function. Please note that the session today is recorded. If you have any questions about Zoom or require technical assistance, please feel free to privately message TF Pravina for help using the chat box. I will now hand over to Annie Khan, who is the South Asia researcher and representative for Business and Human Rights Resource Center. Annie, the floor is yours.
Thank you, Pravina, and good afternoon, everyone, or good morning, good evening for others joining from different regions today. I'm so pleased to welcome everyone to this session with such an esteemed panel at the UN South Asia Forum on Business and Human Rights titled Strengthening Access to Judicial Remedy for Corporate Human Rights Abuses. As mentioned, my name is Annie Khan, and I'm the South Asia researcher and representative at the Business and Human Rights Resource Center. We have with us today some of the most renowned legal minds representing 5 South Asian countries today, and it's truly my privilege to be moderating the session and getting the opportunity to directly engage with people whose work I've followed closely for many years and who are in many ways leading the charge for the recognition and push towards corporate accountability in the region, in their respective countries, and in their respective communities. There's much that we can all learn from their experiences, and I can't wait to hear their perspectives. So just to set the context for our discussion a little bit before we dive in, it's important to note that effective judicial mechanisms are the key to ensuring access to remedy under the UN Guiding Principles on Business and Human Rights. Principle 26 specifically provides that states should take appropriate steps to ensure the effectiveness of domestic judicial mechanisms when addressing business-related human rights abuses, including considering ways to reduce legal, practical, and other relevant barriers that could lead to a denial of access to remedy. As we are now seeing an increased interest by states in South Asia to develop a national action plan on business and human rights, there is now an even greater need to examine the role of courts in providing access to remedy for victims, as laid out in Pillar 3 of the UNGPs. I'll now introduce you to our first esteemed panelists to begin the intervention. The panelists have been asked to consider some guiding questions. After the speakers complete their presentations, I'll ask each panelist a brief follow-up question and ask that they take a maximum of 5 minutes to respond for that. Then I would open the floor up for questions and answers from our audience members. So if you could, please share your questions in the chat or Q&A box, and I'll get to as many as I can, time permitting. So to our first speaker, Mr. Krishnendu Mukherjee. He's a barrister and Indian advocate, and currently practices in both jurisdictions, India and the UK. He has extensive experience in advising, litigating, and using non-judicial remedies in relation to business-related human rights and environmental violations. Krishnendu also has a particular knowledge and experience in relation to the environment, modern slavery, human rights, and environmental due diligence. So over to you, Mr. Krishnendu.
Thank you very much, Annie. And good afternoon, everyone, and thanks for the organizers for the kind invite. I have a short PowerPoint presentation, which I'd like to share. Pravina is sharing that with you. Thank you very much. I think the first thing I'd like to say is India, as a practicing Indian advocate, I'd like to say that India shares similar historical similar history with other countries in South Asia, and therefore faces similar problems when it comes to access to judicial remedies. So we have outdated laws, we have a costs issue, we have a delay and a significant delay in disposal of cases. we have a lack of capacity and a lack of sensitization in judges. We have a lack or poor enforcement of court orders. And all of these have been aggravated and exasperated in the COVID-19 pandemic. So with increasing delays and difficulties in getting cases disposed of or even heard. But I think some of these issues really have to be seen in real life examples, and that's what I'd like to turn to today. Next slide, please. Next slide, Pravina. Yes, thanks. Can we make it bigger? So this is a case which I'm involved with, the Aurora Mines case. And here you see an almost iconic photograph of the Aurora Mines, which are situated in the Indian state of Jharkhand, near the district town of Chaibasa. And the white thing that you see at the back there is asbestos waste. This was an asbestos mine, and it left a lot of asbestos waste amongst a mainly tribal population surrounding those mines. Next slide, please. So the Aurora Mines were operated between 1963 and 1983, after which they were abandoned. HIL operated those mines. HIL Limited is the largest, continuing to be the largest asbestos cement company in India. And in 2013, I filed a case on behalf of a number of claimants who were identified as suffering from asbestos-related diseases in the National Green Tribunal, which, as you probably know, is only one of 3 specialized environmental tribunals in the world, after Australia and New Zealand. And in the course of those proceedings, the court ordered a joint committee to go and visit the site, and they found that there were 2 acres of land that were covered by chrysotile waste, and that there was a risk of 14 villages which are surrounding the mines and the people in those villages being exposed to asbestos, which, as you probably know, is a carcinogen, which has been found to be unsafe to human life since the 30s in the United Kingdom. Next slide, please. And as that case progressed, in 2018, on the 14th of August 2018, a National Green Tribunal passed an order. And in that order, we have the bouquet of remedies which are available to the National Green Tribunal. So a remediation, that's cleaning up of the area, according to the expert committee reports. Identification of those who are injured through exposure to asbestos waste from the mines. Following identification of those who were injured, monetary compensation for damage to land, farmland, and to individual persons who had been injured through asbestos, who had contracted asbestos-related diseases. Order that the polluter should pay. In other words, ultimately it should be HIL Limited that paid the cost of all of this, both the remediation and the compensation, and put it in the hands of the government of Jharkhand, the state of Jharkhand, to implement that order. That was in 2018. What we've found is that whilst there has been some progress in terms of medical camp and so on, where other people have been identified, that because of really the nascent state of enforcement of these type of orders, there hasn't been the kind of progress that we want. So in other words, there hasn't been remediation, there hasn't been compensation as yet, and there hasn't been the polluter pays. And I think that this issue, this case does illustrate a number of problems that currently exist in the Indian judicial system generally when it comes to business and human rights cases. So delay, the National Green Tribunal in its act, in the 2010 Act, says that each case should be disposed of within a period of 6 months. Here it's taken over 5 years. The difficulty in enforcement of an order, and the lack of expertise really in the statutory authorities in enforcing that order as well. Next slide, please. I've been asked to address this question, and I was part of the group that made representations to the Department of Corporate Affairs in relation to India's National Action Plan on Business and Human Rights. And I think the National Action Plan will improve the situation if it recognizes a number of things that are existent in cases like the Aurora case. So the protection of human rights defenders is a major issue, where human rights defenders, people taking these cases, are intimidated or subject to corruption. So that has to be, the anonymity of these cases, or protection of human rights defenders, has to be protected. There has to be some mechanism by which cases which are obviously causing harm, as in this case, harm to the population, are expeditiously disposed of. And I think better training is required to the judiciary in relation to sensitizing themselves on BHR principles, and an understanding of the difficulties in claimants taking cases in relation to access to justice, the costs, the lack of expertise available, and the inequality of arms between corporations and rights holders, including the lack of disclosure, the lack of evidence. And we've also called for a strengthening of the Right to Information Act in the Indian context. Next slide, please. Now, obviously, the concept of mandatory human rights due diligence is something that everyone is talking about at the moment, especially with the EU proposal, which has just finished its consultation. Can it help in a situation like this? I think it can. And here I've copied some of the EU legislative report, which came out on the 10th of March in relation to the scope of a possible directive. And obviously this is still in a draft stage. But Article 2.3 of that draft directive says that the directive shall apply to companies which are governed by the law of a third country and not established in the territory of the Union in this case, but still operate in an internal market. So if this was applied in the Indian context, you would have had due diligence in relation to non-Indian companies. So for instance, the subsidiary in the Bhopal case would come under this. And that, in my view, is a step forward, because whilst we're talking about judicial remedies and not extrajudicial remedies, really they're all related, because failing to do human rights diligence will ultimately involve a sanction, which will come in front of a court. But Article 10 talks about extrajudicial remedies, the obligation on companies in a jurisdiction to take action to, first of all, assess what impact they have on human rights directly and indirectly, but also in relation to remediation, which would be very important in this context. Next slide, please. And it'd be interesting to explore whether the fact that HIL, which is the company which caused the pollution in the Aurora case, now having bought Parador, which is a German registered company, whether under EU law, we could use the human rights due diligence obligations to put pressure on HIL to implement the order of the National Green Tribunal. And that was something that I'd be quite interested in exploring as a way of trying to progress this case. Next slide, please. And obviously, cases like the Aurora case isn't isolated in India. There are many sites of pollution, one of which is the site of India's first asbestos plant in the village of Kaimur in Madhya Pradesh. And the woman in the picture here is Nirmala Gurung. She was an activist in relation to the asbestos pollution, 600,000 square meters of asbestos pollution in her village, who was victimized by the asbestos company when she highlighted the issue, and for whom, and for the rest of the community, we are trying to find ways of using the bouquet of remedies to clean up the village. Unfortunately, Nirmala died last year, not from COVID, but certainly to do with issues surrounding the impoverishment of a community, despite the fact that there has been a working asbestos factory and other factories there for decades. And I dedicate this talk to her memory. Thank you very much.
Thank you so much, Krishnendu. And yeah, I really appreciate the kind of the personal story, which I think is important to include whenever we talk about cases. It's always important to remember the human aspect of things. So I will now move to our second speaker, Dr. Deepika Udagama. Dr. Deepika Udagama is the head of Department of Law at the University of Peradeniya and is currently on sabbatical. Her specialization is international human rights law. She is Sri Lanka's alternate member to the United Nations Subcommission on the Promotion and Protection of Human Rights, and also the UN Subcommission's co-special reporter on the globalization and impact on human rights. Dr. Udagama was the founding director of the Center for the Study of Human Rights at the Faculty of Law. She serves as the chairperson of the Sri Lanka Foundation's Commission on Democracy and Human Rights. She holds an LLB and LLM from the University of Colombo and a JSc from California. Over to you, Dr. Deepika Udagama.
Thank you very much, Annie. I hope you can hear me clearly.
Yes, we can.
Actually, thank you for that kind introduction, but I think it's quite a lot. I mean, I've been involved in quite a lot since, those credentials, although I was involved with those activities. And I want to speak mainly as an academic, as professor of law at the University of Peradeniya, and also as former chairperson of the Human Rights Commission of Sri Lanka, because I think especially my experience at the Human Rights Commission is very important in this regard. Now, today we are focusing on the access to judicial remedies, in particular, which is a very important part of the guiding principles. But I think it is also very important to focus on non-judicial remedies, because we've got to talk about access to justice. And many citizens of South Asia are not in a position to access judicial remedies. But before I address the issue of judicial remedies, let me backtrack a little and get to the type of discourse that's taking place in Sri Lanka on business and human rights. So when you compare with, let's say, India, or let me go out of the region to Thailand, and I'm not quite sure about the level of discourse in Bangladesh and Nepal, Pakistan, Maldives, Bhutan, and so on. But in Sri Lanka, it is still at the stage of discussing corporate social responsibility in the business sector. We are slowly moving towards this discussion on the nexus between business and human rights. So there is a big jump to be made. And a couple of years ago, with the intervention of the Working Group on Business and Human Rights, the UNDP,
and the Human Rights Commission of Sri Lanka joining in that effort. A major effort was made to start a program formally in Sri Lanka to encourage the government to formulate a national action plan in this regard and so on. So it will take time, and the Human Rights Commission was also getting very focused and started on this nexus between business and human rights and entertaining complaints and so on. I wish to point out that when you talk about access to judicial remedies, I think there are many varieties, or at least certain categories of judicial remedies one can refer to. One, of course, is the constitutional remedy for violation of fundamental rights. I think in many South Asian countries, I'm not sure about Nepal under its new constitution, I think it may have moved forward. It's the state entities that are held responsible for violation of the Bill of Rights, the chapter on fundamental rights. And this is a serious limitation in Sri Lanka because it's only the executive branch of government that can be held responsible. There's no horizontal application of the rights that are guaranteed in the constitution, as in, let's say, the South African constitution of 1996. So this is a great fetter. So when cases started rolling into the Human Rights Commission, I was there from 2015 to 2020, and you could see gradually how the volume of complaints against the private sector was increasing. We couldn't give, as a body that provides non-judicial remedies, we couldn't directly address those complaints. We would, write and say, this doesn't come within our jurisdiction, but let's see what could be done. And the avenue, I think, that is left right now to, I'm sorry, there's a bit of a technical issue here, was to get through to the regulators, because the regulators are state entities, and to point to the fact that you are not doing your job properly, you are not regulating. For example, we used to get a lot of complaints about private schools, international schools that are not properly regulated, and the sort of problems of discrimination and abuse that was taking place in some of those schools, for example. In the larger scheme of things, that would be a more simpler issue, but yet children were being affected negatively. So we had to then get to the regulators. So if there are no regulators, we'd ask the Ministry of Education, what are your plans on regulating this sector? Because there are rights being abused in this sector. So I think we need to talk about this constitutional problem. I know Indian jurisprudence, to some extent, the Supreme Court of India has addressed this issue by holding at times private entities also, for example, for emergency healthcare, that private entities also are under an obligation to provide emergency healthcare and so on. But there's no direct way of holding private entities responsible for abuses of human rights. So that concept of lateral application of the Bill of Rights would really provide a great relief to the people, both in terms of getting judicial remedies and in terms of getting non-judicial remedies, for example, from the Human Rights Commission of the country. So of course, people are resorting, and lawyers are resorting to other forms of cases, other forms of jurisdiction of the court quite successfully at times. But I think the symbolic value of declaring even a declaratory judgment that a corporate entity is in violation for abuse of human rights standards, I think is extremely important. So what we see is a flourishing of actions based on environmental law, on the concept of environmental justice, and there have been some very progressive judgments. And then we, of course, have labor tribunals, people moving to labor tribunals for a violation of labor standards. We have action being taken under consumer protection laws. We have cases where action is being taken for abuse of children and so on, under the statutory provisions in those areas. But still, the point is, I think that is inadequate. Now, if you look at, for example, the private sector as the largest employer in the country, or at least a very extensive employer in the country, there isn't adequate remedy I think even labor tribunals can provide when it comes to, let's say, sex-based discrimination, or if there's discrimination against a particular community, there is no adequate remedy. So I think the legal framework itself needs to be very carefully crafted in this instance. But I think in terms of the larger issue of seeking justice for the people and holding the private sector to due diligence standards, I think a whole lot of, we've got to move away from just the debate about judicial remedies and so on. But I think we need to talk about how, perhaps in countries like India, this is not a big major issue. But in Sri Lanka, I think the public discourse has to really expand. We need to learn to, negotiate. We need to use the media to highlight the types of abuses that are taking place, and to use the legal standards, and ideally in a future constitution, because currently Sri Lanka is again in the throes of, at least there's talk about the making of a new constitution. Many of us have provided proposals, which also, among other things, seek this horizontal application of the Bill of Rights. We need to find ways and means of organizing communities to effectively negotiating and demanding from the private sector, together with the authorities that are supposed to be regulating the private sector, to uphold these standards of due diligence. I say this because we can't envisage situations where individuals or even small groups of individuals can effectively seek, or many of them can effectively seek judicial remedies, because access to justice is a major problem in our part of the world. And as the first speaker pointed to, there are many problems, the laws, delays, the costs, all these issues are there. So I think what we need to do is to think of creative ways in which we can hold the private sector accountable. What are the sort of means by which we can? Is it about boycotts? How do we hold them accountable through larger processes, while of course improving the law and improving access to justice in this regard? Thank you very much.
Thank you so much, Deepika. And I fully echo so much of what you say. I think what stood out to me was the jump from CSR to BHR. I think that's the crux of the issue in the region, and perhaps even in other parts of the world. And it remains to be seen how long it'll take for us to get there. But I think, again, as you mentioned, perhaps it begins with the public awareness and people knowing, a bit more about BHR issues. So thank you for your presentation. So our third speaker is Professor Uzair Kayani. Professor Kayani is a faculty of law at SAH-SOL LUMS, Lahore. Professor Kayani teaches torts, commercial law, and law and economics. His research interests include law and economics, political science, and international law. Professor Kayani has previously led the ABA program on strengthening the rule of law in Pakistan, and is currently leading the Business and Human Rights program in collaboration with the ABA. Specifically in relation to BHR, Professor Kayani attended the American Bar Association Rule of Law Initiative Emergent Tour for Pakistani law faculty in 2019 in the USA. Professor Kayani has also developed and launched a pilot Business and Human Rights course at LUMS. So over to you, Professor Kayani.
Sure thing. Thanks so much. So it's a pleasure to take part again in this regional conference, and I've been given 4 questions, which I'll try to spend an equal amount of time on, but some will be more complex than others. And again, 10 minutes isn't going to be enough time to cover all of this, so I welcome questions later on to expand on this as well. So the first question was the judicial remedies that are available in Dagestan right now for these human rights abuses connected somehow to commercial activity or business activity. So I'll list many of them, and then I'll list some of these quasi-judicial remedies that are also available. And then I'll just speak briefly about some of the limitations that we run into when we're dealing with these. So first of all, there's the constitutional power to take cognizance in hard law, to take cognizance of human rights issues. And the main place where that's exercised is at the Human Rights Cell of the Supreme Court. Article 184.3 of our Constitution of Pakistan, there's similar provisions, I believe, in the Indian Constitution. These give suo motu powers to the Supreme Court, which are unusual in the common law world in the sense that the Supreme Court can take cognizance of a matter where there's no plaintiff. So what's happened as a result of that is that the Supreme Court several years ago made a cell called the Human Rights Cell, where anyone could write in and send in complaints that a fundamental right that's of public importance has been violated, and the Supreme Court would, at its discretion, pretty much, decide which cases to pick up and which not. And beyond just the cell, the Supreme Court by itself would also pick up certain cases. So that has become a very powerful venue since 2010 or so, when the Supreme Court became politically much more active and much more salient in the public sphere. The drawback of that is that a lot of that activity depends on a pretty tenuous or overbroad definition of what are and what are not human rights. So the main problem that can result in is that sometimes on the basis of this human rights, fundamental rights jurisdiction, which is really supposed to be for the most part human rights jurisdiction, the Supreme Court can sometimes come into conflict with core prerogatives of the coordinate branches, the executive and the legislative branches, because oftentimes the line between what is a human rights issue and a policy issue becomes blurred. There's a similar power, secondly, in the high courts. So the high courts, you do need a plaintiff to come in, but there's a writ jurisdiction under Article 199, where if a plaintiff comes in and the plaintiff says, well, there is this, one of my core rights has been violated, then under 199(1)(c), the court has the power to issue writ jurisdictions. If you look at it textually, to both public and private parties, but in practice, it's only been applied predominantly to public public institutions or the government institutions. One way that lawyers will typically go around that or use that provision, the 199 writ jurisdiction, to go after private parties is to say, well, this private party is violating my rights because this public regulator is not stopping them. So they're going to essentially bring the writ case against the public regulator and also bring in the private party, join the private party in some fashion. So these two methods are used, but again, the cost issue, which was raised by our first speaker, is extremely relevant here. The High Court and Supreme Court avenues are typically only available to the well-heeled. So they don't extend to generally people who are not of sufficient means and who really are the most vulnerable. A third method, which can potentially extend to a larger variety of people, is quasi-judicial. And these are the ombudspersons that operate. And I have a great deal of personal experience in one particular ombudsperson regime. So that is the sexual harassment ombudsperson. And they exist at both the federal and the provincial levels. So violence against women and harassment against women is one of the main areas where Pakistan, I think, has a very big problem that everyone knows about. And so every province, as well as the federal government, passed a Protection Against Harassment of Women in the Workplace Act, which required that every private company establish a committee, an inquiry committee, which had to take, and I've served on several of these committees, which has to take every complaint that's brought to it, investigate it, and then there's a band of penalties and actions and so forth that it's supposed to take. Again, that hasn't been implemented that much. So even though by law, every private entity of a certain size has to have these inquiry committees, anecdotally, what I know is that very few of them do, as in less than 10%. Maybe what I've heard is even less than 5%. Generally, nobody has them except for universities and some particularly progressive businesses. But the ones that do have them have a very heavy caseload. So that signifies that there is a very big problem there. So the committees, when they make decisions, or in case there is no committee that they can go to, instead of the committee's decision can be appealed to the sexual harassment ombudsperson, or if there is no committee, a direct complaint can be made to the ombudsperson. The main obstacle now that is accessible to pretty much everyone who is working in the formal economy. That's again an important distinction, because most people in Pakistan are working in an informal economy where pretty much none of this applies. But the folks who are working in a formal economy, women working in a formal economy in particular, when they bring these cases to the ombudsperson, the main obstacle that occurs there is cultural. So our experience has been, at least with committees that I've been involved with, is that there are many instances where we would find inappropriate conduct and act accordingly, but we would be overturned by the ombudsperson because the ombudsperson would not consider that conduct inappropriate. In fact, some of you will be aware of a related judgment that I'm sure made a lot of noise in India, also made a lot of noise in Pakistan, about what was and what was not sexual harassment or sexual assault of a child. There was a court judgment, which again reflects some of those cultural problems that I think are common among several South Asian countries. So there again, that's the third avenue, and then the obstacle. A fourth avenue is mediation, and the most common place where this happens is, well, there's two really. The most common place where this happens is through the OECD national contact persons. And a lot of union activity or union protests are actually filtered through or directed through that avenue. So unionization has been curtailed a great deal over time in Pakistan, and it's an old story. It happens all around the world. It's been especially aggressive in Pakistan. But if the union, if the laborers or employees in a particular business are unionized, and their rights are being violated, most typically what happens is that they don't get paid for 5 months or 6 months, or they don't get the benefits they're supposed to get, then they could go to the labor tribunals. Those are also present. But many of them will instead choose, in the cases where there is a parent company that is in an OECD member, or if there's a company which even if it's not strictly a parent, it still has a strong enough control over their own employers, then they can reach out to the national contact person in the country where that parent operates, and the national contact person will then write a letter to them, confront them with the accusations. It's a mediation type of process, but it actually tends to work reasonably well, at least on paper, because the companies take their reputations very seriously. So that's a fourth avenue. And a fifth avenue, as was mentioned before, I just put these three together, are the specialized courts. So there is the labor tribunal. There's also the commercial courts that have recently been created in Pakistan. And the main way in which they become relevant is if the company, again, typically this will be a parent company, they put into their contract certain human rights due diligence requirements, which has become an increasingly strong demand from their own investors. So when FDI comes in and these companies make relationships with Pakistani companies, there are contractual terms which can be enforced in commercial courts. There are environmental courts. Again, those are not as active as you would like them to be, but they do exist. And again, a lot of the environmental public interest litigation, as it's called, activity that has happened instead at the Supreme Court level through 184.3. But the environmental courts also exist. And then the consumer protection courts, as was mentioned by speakers before as well. So those can actually use, in many cases of gross negligence or injuries caused to consumers, those can be used to protect these consumers as well. So I guess those are the main remedies. And I'm sorry, I'm going to need, just let me know when my time is up and I'll stop then. I think I took longer on that than I meant to. Critical barriers faced by victims was the second issue. I think there are two mainly. The first one is there's no access to legal representation, very limited access to legal representation. There's been an issue not only for civil conduct, which is more common, but even for criminal conduct, where by right you're supposed to be able to get representation and matters of that nature. So because of the existing backlog of the cases and because of no existing culture of pro bono work in Pakistan, most victims simply cannot afford any kind of legal representation or secure it. So that's one barrier. The second barrier, which is even greater, which is something we're working on right now, is cultural. And what that is that in many cases, human rights abuses are not even recognized as abuses. In contexts that we didn't really think about before we started working in this area. So right now we're working on the protection of children. And as I mentioned, the two main groups, the usual suspects almost, who are most vulnerable in Pakistan are of course women who are in employment. If they're in formal employment, they're still better off because they can get access to the ombudsperson and so forth. But if they're in the informal sector, such as agriculture, or a lot of retail, which is also essentially informal outside of the cities, they're extremely vulnerable, and they operate in situations where harassment is quite common, and under circumstances which are very close to bonded labor. And this again, a very typical example of this is domestic labor. People living in other people's mansions and houses and their servants' quarters with absolutely no protection whatsoever. In many cases, their ID documents and so forth are taken over by the employer and they're paid nothing approaching a fair wage and so forth. And then with children, again, I can recommend to you folks on YouTube, there's a documentary called Pakistan's Hidden Shame, which talks about this culture of almost institutionalized sexual abuse of children in the trucking industry and related industries in certain parts of the country. And we became aware.
If you can just wrap up, please.
Yeah, I'll just conclude quickly. So
we'll come back to you later too.
Yeah, so I'll just very briefly say those are the main obstacles, I guess, and we can come up. If there's further questions, I'll ask those at answer at that time. Thanks.
Thank you so much. That was very interesting, and I think we'll definitely come back and kind of get into a little bit more. One thing that stood out to me, which I think applies to all countries in South Asia, was the informal and formal distinction, and I think it's very important to highlight that fact because we live in a region where, in most of our countries, the majority of the workforce is informal. So when we even start to deliberate upon access to judicial remedy, there's so many people that we can't even talk about because they're just, they don't even have that access. So I think that's a very important point to make. So I'll now move to our fourth speaker, Mr. Shankar Limbu. So Mr. Shankar Limbu is a human rights attorney with the Lawyers Association for Human Rights of Nepalese Indigenous Peoples, LAHARNEP, and a leader in his field. In his role with LAHARNEP, he provides free legal aid services and works to promote, protect, and defend the human rights of Indigenous peoples in Nepal. He's also a board of trustee at the United Nations Voluntary Fund for Indigenous People and executive committee member at the Asia Indigenous Peoples PAC, AIPP Foundation. He's also a legal advisor for numerous IPOs in Nepal. So over to you, Shankar.
Thank you very much, Annie. Good afternoon, everyone. Just to correct about my positions, I was a former board of trustee and no more. And then I was a former executive member of the AIPP and no more. So this is a legal matter. Probably people are gonna sue me if I'm still using my former positions. Okay.
Apologies.
So, right. Well, first of all, it's my great privilege to speak about this very important forum, and it's about very important issues. Well, when we talk about the access to remedies in relation to business and human rights, if we're talking about Nepal, we have two kinds of remedial mechanism. One is a judicial, and that is more state control. We have like non-judicial, that is more community control mechanism. So the state control mechanism, obviously we have like three types of court: the Supreme Court and High Court and district courts. Some of the issue we can bring into the district courts, and some of the issue we can bring in the High Court, and mostly we prefer to bring the issues in the Supreme Court because of effectivity. But there are challenges. I'm going to talk about that later. When we talk about the non-judicial remedies, that is mostly, there are two kinds of non-judicial remedies. One is like National Human Rights Commission that has also what I category, it's more or less, it is also the state sides of National Human Rights Commissions. If I say about the state sides, why? Because those, the members of the National Human Rights Commissions are appointed by the government. So that's why. But there is another kind of non-judicial remedial mechanism, which is community controlled. Let's say if we talk about the indigenous people's context, they have like customary law and customary institutions, which is more active in the community level, and the community control them, and then that can ensure the access to justice and more compatible to the community context. That's the category we talked about that, and the next one is when we talk about the business-related human rights abuses or violations. Can we bring these abuses? I mean the cases in this in the court? Yes, obviously yes. What are the success? It depends on the cases. It depends on the judges. So that's why when we read about the Constitution, and it talks about the competency of the court or judicial system and independence of the judicial system. But when we really use the system, it's very often confusing. Why? Because the first thing is still the court and the independence and competency is in the questions, because the judges are appointed by the government. And what kinds of judges are appointed? That's the judges or the lawyers. Even there are two kinds of judges. One is the cadre judges, and other it's brought from the practicing lawyer also, but who are very much associated with the political parties, let's say the ruling parties and opposition parties, the lawyers, and even the cadre judges. Then they can be brought in the Supreme Court or High Court. So we can imagine that, and we can raise the questions about their competency also. I'm not saying that all judges are like the same. Let me give you about some, as a practicing lawyer, when we bring some cases, maybe it will be good to share about that. And we have like good judgment also, but most of the judgment, the decision of the court is not in favor of the victim, I mean, in favor of the people. It's more in favor of the company and in favor of the government when it comes to the business-related human rights violation cases. One case that I would like to talk about, the infrastructure development case. We got like landmark judgment. I guess that is that is the first case and groundbreaking judgment in the context of Nepal, because the full bench made the decision against the government, because the government wanted to construct the road and other infrastructure that displace the communities and that displace the other the people as well, the local people as well. It's not very far. It's in the Kathmandu Valley, where almost 150,000 people might be displaced, and they might turn into the homeless. But what we did, we brought the case in the Supreme Court. Supreme Court made the very good decision against the government, and it clearly says about that. You can go for the development. Government can go for the development, and the company can go for the development. However, we cannot compromise the fundamental rights of the people, like right to housing, right to culture, or I mean the fundamental right to culture, and also the the concept of development, it was well defined, because the government always, everything is covered by the term development. Let's say the word development is being very problematic. But the challenge when we talk about, even we got the very good judgment in favor of the people, in favor of the victims, the implementation, when the questions comes into the implementation, it's a very selective. In some area, it was implemented. In most of the area, it was not implemented. Even the same case. So what we did it, we raised the questions. We filed again another case of non-compliance of the decision of the Supreme Court, but nothing happened. Right, so that was the one. And when another recently, we got a very good order from the Supreme Court. It's related to one hydro project. Actually, that was also another landmark order. Almost the hydro project was completed. However, the people, their life was under the threat because the hydro project, it was constructed without taking care of the situation of the people, that how they would be affected. They would be affected in their land, they would be affected in their houses. And then there was a huge issue of the corruptions. So if you looked about the document of that hydro project, and everything is perfect. You see the EIA document, you see the SIA document, and other the feasibility study that mentions very well that they will protect about environmental issue, they will protect about the people's right, they will protect, they will respect about the fundamental rights and the human rights as well. But on the ground, that was nothing happened. So the Supreme Court ordered to re-examine the project. So we came to know that, maybe it will be good to share about this one, what we came to know that the Supreme Court, when the Supreme Court ordered to form a commission of 3 ministries from the, I mean, the members of the 3 ministries, like Ministry of Energy, Ministry of Environment, and another is the one Nepal Electricity Authority, which is the government sole entity to take care of the hydro and the electricity business in Nepal. So, but they wanted to just bypass the affected people, and then they have to go to the field. But what happened is the company, I don't know why, the company already, they have like a kind of contact with the ministry. So the affected people, they went to talk to the ministry, and they said that we are not going to talk to you, and then we just go there. We see the site, and we will prepare the report, because we have to complete the report and submit to the Supreme Court within 2 months. So what we did it, after hearing that one, immediately we went to the community. What I was, what I wanted to say here is to ensure the access to remedy, then we have to be very open. We have to explore the different areas, and then lawyer, the traditional court practice, the traditional legal practices, you just go to the court and you do the pleading and you come to the chamber. It doesn't work at all in the human rights, the business related human rights abuses, or if you want to make accountable to those companies to make sure that the human rights or the rights of peoples are not violated. So the lawyer has to be very, very much open and then creative. We went to the community together with our colleague, and then we talk to the local government authority. I guess that is the unique case in the context of Nepal. We have like 3 tiers of government in the federal structure. The local government also have some sort of power that can rectify what the state government or what the federal government made the mistakes in relation to these business activities, or granting the license or operating any development activities. Then, and then we also mobilize the traditional or the community organizations who are very community leaders as well. So that's why the team of that investigation, I mean, the member of the investigation team, they were compelled to listen to the affected people. So that's how that's the another cases. So what are the the critical barriers? In general, would I say that the concept of the judges, or concept of any decision makers from the non-judicial mechanism or quasi-judicial mechanism, it's very wrong. When they talked about the development, they close the eyes and then they favor to the government. So that is very much problematic. And indigenous peoples, because my organizations, we help, or we work to defend the indigenous people's human rights violations. But while doing that one, we don't discriminate. We also apply the non-discrimination policy. So if they are affected, non-indigenous peoples are affected, and we also deal about that cases in the community, but we have to do that one. But in the context of indigenous peoples are facing the racism. The racism is in the judicial system as well. There is a structural discrimination, systematic discrimination against indigenous peoples. So that is the biggest hurdles to access the justice for indigenous peoples. Because the indigenous peoples, when they talk about the land rights, when they talk about their customary rights, and the judge in the courts, they have like a concept that we're talking about the communal things. We are going to jeopardize the social harmony. That's how that they think about it. Even if we bring that kinds of cases, as a lawyer, they ask several times, and we have to face that kinds of questions from the bench. And the second one is the concept, as I say that, there is no clear concept about the collective rights in the judicial system, the state judicial system. And then they only talk about the individual human rights violations, individual rights violation cases. But when we talk about indigenous peoples, then if we don't understand about the collective human rights concept, then they will not have any justice. So the access to justice for indigenous peoples in this context, it becomes like nil, right? So the third one is the court system is not only technical, but it's very expensive. When you have to pay a high court fee, and so how we can ensure the access to justice. So that is the another barrier that for the access to justice. Well, how we can overcome about these kinds of issues, I guess.
Sorry, Shankar, you can just wrap up, and then we'll come back to you in the next round.
All right, thank you very much. Yeah, we should, I mean, there should be a clear recognition of the collective rights, and there should be a clear recognition of the not only the judicial or quasi-judicial, but the customary and traditional institutions who also deliver the justice very effectively. And so I should stop here. Okay, thank you.
Thank you so much, Shankar. One thing that stood out to me was the discrimination piece. And I think that's something we also should always remember, that there's some inherent discrimination, whether it's caste discrimination or religious discrimination in many of the judiciaries in our region. And I think that's something that has to be addressed first if we want to talk about equitable access to remedy. So I'll just go to a couple of follow-up questions that I had prepared, and then we also have some Q&A questions that are coming in from the audience. And unfortunately, Sayada Rizwana, who was our representative from Bangladesh, had a family emergency, so she couldn't join us today. So we have one less speaker, but nevertheless, we'll continue on. So I'll ask the first follow-up question to Dr. Odagama, if I may. So I just wanted to share, from your vast experience with the NHRC and the other activities that you've been involved in, would you be able to share an example of a successful intervention by the NHRC or the judicial system in Sri Lanka in general for victims of human rights abuses in the context of business? Is there anything that comes to mind, or any sort of best practices that you may be able to share?
I think they're still muted.
Dr. Odagama, are you with us? Okay, so maybe I'll just move on and see if she joins back. Professor Kayani, to you, something that I've been thinking about, and maybe you can shed some light on, is the idea of increased international investment in the region. So whether it's Pakistan or Bangladesh, we do see EU-based companies, for example, setting up shop and looking for alternatives to China or other countries. So with this kind of increased international investment, do you feel it would be more or less difficult to access the judiciary if, for example, a multinational operates locally? And have you seen any such transboundary cases being litigated in and out of Pakistan? If you have anything to share on that.
Yeah, sure thing. So there have been a few prominent cases. So there was one involving a factory fire in the southern area of Pakistan, around the Karachi area. There were actually a couple. And in that case, what happened was that some of the litigation actually happened in the parent company's jurisdiction of Germany. So, and the UK also offers similar venues. The US used to, when they had a stronger alien tort statute, but then the Supreme Court kind of contracted that. So that is an option that has been used and is only available in situations where there is foreign direct investment or almost a relationship that the judiciary of that host country, of the parent company's country, would recognize as a controlling relationship. So we have had those cases. The problem with those typically tends to be implementation again in Pakistan. So you might get an award of damages, which is accepted by the subsidiaries or the relevant actors in Pakistan, but then the damages are not paid and there's not enough follow-up to actually see whether it's happening. But at least you get the precedent, which again has some value. More generally about foreign direct investment, there were some really good outcomes, but they're more on paper, and there's less implementation that we would like. It's still positive, but not as positive as it might look at first. So one step was, and this is from really, this is more a trade perspective. Pakistan hadn't ratified a lot of the main human rights treaties that most of the world had until the European Union created an incentive by saying you're going to get the generalized system of preferences plus the GSP plus status if you do. So that created an incentive among exporters in Pakistan to pressure the government to sign on to these. So that was a great outcome. The drawback was, well, not a drawback, but a limitation was that the treaties you sign in Pakistan are not domestically enforceable unless there's domestic implementing legislation on top of that. So courts don't generally apply treaties directly. So, and there hasn't been a great deal of domestic implementation of those. The other potential problem is that the profile of foreign direct investment in Pakistan has changed somewhat. So the kinds of ameliorative or helpful human rights effects that we were seeing when the FDI was predominantly coming from Europe or the US are not the same as the ones we're seeing now that the foreign direct investment is coming primarily from elsewhere. So not all countries have as strong of a program of actually affecting the legal and social status of the countries that they're investing in. So that's an evolving situation. I guess I can expand if you like.
No, that's fine. Thank you so much. Deepika, were you able to connect? Okay, so should I repeat my question?
Sure.
Okay. Yeah, so I was just asking, from your vast experience as chair of the NHRC and the other activities that you've been involved in Sri Lanka for a long time, can you share an example of perhaps a successful intervention by the Sri Lankan NHRC or the judicial system in general for victims of human rights abuses in the business context, or some kind of best practices that maybe you can share with the group?
As I said, we were just starting out, the Human Rights Commission, to look at complaints against private entities that were made by the public. And when we left office, we were in the process of, examining those complaints. But in a couple of cases, for example, one case where a private company was tapping groundwater to bottle mineral water, we held discussions with the regulator, and there was an undertaking, some sort of an undertaking to, at least be much more cautious when granting licenses. So I can't say those are successful situations because, it was just the beginning, and the discussions didn't end up in something spectacular where because the Human Rights Commission, as you know, is a non-judicial body, and what we can do is to mediate, or we do inquire into and give, make recommendations. So implementing a recommendation is extremely difficult. But this is why I said that what is more important perhaps in South Asia, while we are focusing on judicial remedies and indeed the non-judicial remedies, which may be more relevant to the average citizen, to be able to take up these causes at a political level, because that's the way people leverage their political power as citizens and as voters to get the authorities to do what it takes. Where the courts are concerned, actually, there has been no judgment as such holding private parties as the duty bearers, as I said earlier, because the Constitution doesn't permit action on fundamental rights violations against private parties. But I think the success stories are cases where, in the environmental field, where, let's say, the Urban Development Authority has been held responsible for granting licenses in a manner that violates environmental laws. So there was that I would say was a spectacular judgment where the government had granted a license to a multinational company to mine phosphate in the largest phosphate deposit in the country. I think in the South Asian region, it was considered to be one of the largest. And so the people very successfully, together with the whole group of scientists and academics, lawyers, who appeared for them in the public interest, the court gave I would say from a Sri Lankan perspective, perhaps even internationally, a historic judgment which referred to the concept of public trust, and that the state holds these natural resources in public trust on behalf of the people, and that the granting of the license was a violation of the people's rights. So there are two different ways of looking at it. One is holding the state responsible for acting in a manner, for granting licenses, etc., for permitting private parties to act, engage in commercial activities that is in violation of people's rights. And the other is to hold the business entities directly. So I was more referring to the second, where I think our laws need to progress towards that of holding business entities responsible for abuses of human rights directly via the Human Rights Chapter or the Fundamental Rights chapter. So I would say in terms of best practices, we've seen successful litigation emerging in the environmental law area. There is no provision in the Constitutional Bill of Rights on environmental rights of the people or rights of the environment, let's say, like in New Zealand, we don't have that sort of a provision. But under environmental law, the courts have held very progressively. This one exceptional case I referred to earlier of the phosphate mine was, of course, brought under fundamental rights jurisdiction of the court, where the court held the public authorities responsible for granting a license without having an environmental impact assessment test. And there was no due diligence on the part of the state. And that, the license issued to the multinational company was annulled on that basis. So I think while we are trying hard to find ways of raising arguments within the existing law, the legal framework also needs to improve a lot. But once again, I would say that access to justice is such a luxury in South Asia that we've got to think of finding alternative methods, because the Bill of Rights also has to be used politically. So I think we need to focus on that as well while we are talking about litigation and so on. Thank you.
Thank you so much for sharing the best practices. And maybe the success stories are not as common or as frequent as we would like, but I think it's important to also put a spotlight on those situations as well. When things do turn out positive. So I'm just going to move to, we've received a couple of questions from the audience. So I have one question here that's to Shankar. So I'll just share this question. So has the increase in international financial institutions, IFIs, interventions such as World Bank and ADB in Nepal also led to a subsequent change in the legislation in Nepal, such as in the environmental and land laws, in order to ease entry of investors and businesses? Are there any local judicial mechanisms in place to challenge this and address the violations of projects funded by IFIs?
Thank you for very important questions. We've been dealing number of cases relating to the hydro project and other infrastructure development that is funded by international financial institutions. They have their own safeguard policies. However, it has like some sort of moral obligation, but we can use those safeguard policy and also empower the community. They can use as a tool for demanding their rights and also opposing the human rights violations and a kinds of empowerment tool the safeguard policies are. The one case about Upper Tirsuli Hydro project, we were successful to implement free, prior, and informed consent for indigenous peoples, and then they make a kind of protocol for obtaining free, prior, and informed consent. That is also the positive steps. And recently, one EIB, European Investment Bank, funded the transmission line cases from Lamjung. Now we heard that a mediator is hired, but we haven't got full disclosures about this one. This is the recent one. And the good thing is that using these safeguard policies together with international human rights instruments, such as like ILO Convention 169, United Nations Declaration on the Rights of Indigenous Peoples, and as rightly Professor said that UDHR and then the ICCPR and ICESCR, we were successful. We got some sort of success that the community can negotiate with the companies and also with the government, and they can assert their rights, such as like the land rights and the customary rights as well. But does it have influence on law making process or making a legal instrument? I don't think so, but it has very minimal influence, because recently, a year ago, some of law has passed that recognize community property, that's some sort of related to the lands for the community, that includes the indigenous peoples as well. And for the environment, yes, of course, for the environment, the court is quite quite aware that how the environment can be protected, and there are number of jurisprudences which is very good in order to protect the environment environment. So it has, like, we have new environmental law that is not perfect, but however, there is some good provisions that the community can step in if there is the environmental pollutions created by the companies as well. Obviously, there is no jurisdiction for the international financial institutions, but in the context of Nepal, if any company is registered, even that is the multinational company, so that, that we can bring the case against that company as that the domestic jurisdiction is applied for Nepal. And also there is one very good legal provisions which have, it's a Treaty Act. The Treaty Act is very strong in the context of implementation international human rights instruments. It says the section 9, which says that the provision of international law is equivalent to the provision of national law. If there is inconsistency between the provisions of international law and the national law, the provision of international laws prevails. So there are a number of the court jurisdictions. It's set up to implement these provisions of the Treaty Act, which is really good. Maybe that's I should stop here.
Thank you so much, Shankar. I have actually two questions, I think, for Krishnendu. So I'll just start with one, which maybe you've kind of touched on already regarding the Indian NAP. But the question is, does the Indian NAP have the scope to address the ongoing dilution on environmental laws and regulations? For example, currently the Ministry of Environment is looking to merge the Environment, Water and Air Act and dilute the AIA process, and also to create a single window clearance for mines. This makes it even more challenging for civil society organizations and communities to hold companies accountable when they're being allowed to pollute with complete impunity.
Well, that is obviously a crucial point. I mean, at the end of the day, you have companies which are reforming. The Indian state is reforming, inverted commas, laws to relax environmental protections, to lax labor protections. We would hope that within that, the National Action Plan will provide a clearer path, a more regulated path to people who can take action in relation to human rights and environmental violations. And that is possible. Those two contradictory positions could exist. You can have a dilution of human rights protections, but a strengthening of the path to trying to challenge those protections. So really, we hope that the recommendations that we provided as a group are taken on board, so that the whole issue of access to justice, which has very absolutely been properly highlighted by all the speakers today, is something that we can make some progress on in the next few years.
Thank you. And there was one more question to you on the Aurora Mines, so I'll just put that to you now. So this person would like to know whether India recognizes legal person's liability, and two, what difficulties are faced once the proof of process is undertaken against business for human rights violations. And a third part of the question, is the state being held responsible to some extent?
So the first thing I say is that, as lawyers, what you want, activist lawyers, human rights lawyers, environmental lawyers, what you want is obviously systemic change. You want to see a case that you do have a much wider ripple effect in terms of changing the systemic nature of these violations. And for that, it's absolutely crucial that you have the state as a party. And that is why, obviously, in public interest litigation in the high courts, first of all, that you need a state as a party, but secondly, that you are asking the state to do various things and also provide compensation for its own negligence in terms of not enforcing law or violating law in some cases. In the Aurora case in particular, there were a number of state organizations that were parties, and indeed we highlighted the fact that the state had been negligent in not enforcing pollution control laws. But in the end, we felt that it was better to be very specific on the company in order to take the law forward, or at least clarify the law. And so we argued inter alia that the company OHCHR Limited held a strict liability for pollution following its hazardous activity, even if it abided by all the norms of closure of the mine at the time, which is what it's argued, because it was very unclear whether they had complied with properly closing the mine according to the regulations existing at the time. And the court was with us and found that the strict liability principle, which is followed from the Bhopal jurisprudence, did apply in that case. Locus standi is very flexible in the context of the National Green Tribunal, and they are more amenable to looking at pollution cases rather than cases which challenge, for instance, environmental clearances, because projects that seem to be good and everyone understands that pollution is harmful. So there is a juxtaposition there between these two different types of cases. In terms of, I think, what was the second part of your question was the difficulties faced. Well, a whole number of different difficulties obviously are faced, really in terms of evidence, right from the fact that the majority of claimants didn't have any employment documents. Not only did they not have employment documents, but all of their ID documents were all inconsistent, which is not atypical in Indian context, especially among poor and marginalized people. Also, the company said that chrysotile asbestos was not as harmful as other forms of asbestos, so we had to get evidence about that. So every step on the way when you're doing these type of cases against corporations, and obviously that's a universal understanding, will try and fight every single part, and the Aurora case was no exception to that. But really, when we're looking at taking actions in terms of human rights relations, we need the state to be involved, and we need the state to be more cooperative in terms of what it does. So a perfect example again is, for instance, earlier on this week, I did something on the Rajasthan sandstone industry. The Rajasthan sandstone industry has 3 million mine workers, but the central state only has a record of 40,000 workers. And it's clear that if those 3 million workers want to take any action on human rights violations, they need to be documented by their employer, or they need to be documented in terms of their work. And for that, there is no other option than the state to enforce that rule. So it's absolutely essential that we bring the state involved.
Thank you so much. That was a 3-part question, but yeah, I think mostly answered. So thank you. And I can see we're kind of reaching the 90-minute mark. So I will go now, if it's okay, to Professor Surya Deva, who, as you all may know, is a member of the UN Working Group on Business and Human Rights, just to share brief remarks from his side. Thanks.
Thanks, Annie, and thank you all the panelists for sharing some common themes and some unique characteristics from different countries from South Asia that we discussed. I think there's a lot of work that needs to be done, and I think the NAP process could definitely contribute to that if NAPs are done properly in an inclusive manner and there's a political will on the part of the government. I just want to add a couple of quick points, perhaps which were not discussed that much. My first point is about tort litigation. I think in South Asia, because of the reliance on public interest litigation, I don't think we have made enough use of the tort litigation, which is far more developed in a jurisdiction like UK and Canada. So I would really encourage lawyers in South Asia to make use of better the tort principles. And I think in Bhopal, for instance, some principles were developed, but they have not been used that extensively and effectively, in my view. The direct duty of care principle that has evolved in the UK, so can we use that, let us say, in courts in India? So I think that is something worth pursuing. My second point is that I think we should also look at access to remedy in South Asia, also outside South Asia. If there are companies with connections, either the parent company is based there or it is a foreign company but operating in South Asia, and so in either of those two situations, you may look at collaborating with the lawyers in other jurisdictions. So I think this collaboration amongst lawyers is going to be very critical going forward, in my view, from one country to another country and one jurisdiction to another jurisdiction. So I think that is something worth exploring, how we can collaborate with legal councils in other jurisdictions. I think I will stop that. Of course, there's a big elephant in the room, that is informal economy. But I think that will demand a separate session in itself, because access to remedy in the informal sector is quite challenging, and it creates its own set of challenges. Thank you very much, everyone, and back to you, Annie.
Thank you so much, Surya. And I think there was maybe a little bit of confusion on whether this is a 2-hour session or a 1.5-hour session. But either way, I think we don't have any more questions from the audience as of right now. Of course, there's many other questions that I could ask, but I'll spare everyone their time. So I'll just close by sharing a part of the Office of the High Commissioner's Accountability and Remedy Project report, which I feel really ties together many of the themes that were brought out today. So the part of the report says, rectifying these deficiencies, that is everything that we discussed today, which in many cases are rooted in wider social, economic, and legal challenges, will not be straightforward. It will require concerted and multifaceted efforts from all states, encompassing actions relating to law reform and legal development, improvements to the function of judicial mechanisms, law enforcement, policy development, and closer international cooperation. However, this is essential work towards realizing the imperatives of accountability and remedy for business-related human rights abuses. So I guess we all, are working every day towards rectifying these deficiencies, but there's no straight path to do so. But I think, coming together like this and having fora like this where we can discuss it a bit more is one step further. So I appreciate everybody taking the time today. Thank you so much to our esteemed panelists, our organizers, ICJ, UN Working Group, and of course the Business and Human Rights Resource Center. So thank you all for your time. Thank you, everyone. And I hope everyone has a great day.
Thank you very much.
Thank you all. Stay safe.
Thank you. Thank you very much.
Bye.